So let's give Tony and Midwest Environmental Advocates a very warm and well-deserved welcome for the presentation.
Well, thank you so much, Nancy, and I just want to thank Citizens for a Clean Wausau. I want to thank Tom, Terry, the whole group for inviting me to speak and participate today. As Nancy said, Midwest Environmental Advocates is a public interest environmental law center, and we, as Nancy said, we seek to combine the power of the law with the resolve of communities facing environmental injustice to secure our rights to a healthy environment. And I'll say that in my time working at MEA, the relationship with Citizens with a Clean Wausau has really been one of the most effective and inspiring relationships that we've had with community groups. I'm continually impressed and inspired by the sophistication, the knowledge, the resolve, the tenacity that happens not too far from here on the southwest side of Wausau, so it's a real honor to be here. And you know, I was just thinking about the organizing that's already happened in this room this morning as people are making connections and contacting their legislators, so it's just really great to be here. When Tom asked me to talk, and he told me about the groups that would be present here in the room, and also the fact that, you know, we've got a regional audience from across the Midwest. I was trying to think about, you know, what I could share that would be relevant. MEA does a lot of work on Wisconsin-specific issues, but I want to pull out some themes from what we've seen here in Wisconsin that is definitely relevant to those of us who are here in the state, but could also be relevant to our folks from other states and federally. And one major theme that we've seen at MEA, and it's a theme that I want to pull out for our time together today, is the fact that, let's face it, in Wisconsin for the last decade plus, we've been a democracy-challenged state for reasons that I'll talk about in a little bit. And at MEA, we've seen how that undermining of democratic, lower D, democratic accountability has threatened environmental health in our state. It's threatened the functioning of bedrock environmental laws. And I will say that, you know, these are some really significant hurdles and obstacles that we've been through what feels like a pretty dark period in our history of conservation and environmental protection in the state of Wisconsin. But at the same time, I want to lift up the fact that we've seen tremendous resolve and tenacity from groups like Citizens for a Clean Wausau, that we've scored victories even when the deck was stacked against us. And so I'll talk a little bit about that. So in the description for my talk, I said Wisconsin, here in our state, that we've become a testing ground for rollbacks that pose a threat both to democratic institutions and to bedrock environmental laws. And I want to focus on one, I think, pretty clear-cut example of how Wisconsin has become that kind of testing ground for some pretty radical ideas, and that is the RAINS Act, which has an acronym. It's you know, the idea is that it's supposed to rein in the government regulations from the executive in need of Scrutiny Act. And I'll talk about this RAINS Act in just a minute, but I want to give those who are maybe listening or here not from Wisconsin just a little bit of history, political history of what's happened in our state. And folks know that in 2011, there was a pretty consequential election where Governor Scott Walker was elected and Republicans took control of both houses of the state legislature. That happens from time to time in Wisconsin, a purple state. But suffice to say that, you know, governance in our state took a pretty sharp right turn. And, you know, this happened when the redistricting was up because the census had occurred in 2010. And so legislative districts were being redrawn, and given those circumstances, Wisconsin instituted one of the worst gerrymanders in modern American history. And the impact of that for us has been that for the last decade or so, the leadership of the legislature has, you know, to put it frankly, cared very little about the opinions and the views of the majority of Wisconsinites. And the legislature has been structured rather to be accountable to a very small percentage of the electorate that votes in Republican primaries and to the special interests that dominate Republican politics. And I talk about all this not to be partisan in terms of, you know, parties, but to just be factual about what we face here in the state of Wisconsin. An erosion of democratic, lower D, democratic accountability is bad no matter which party is doing it. And that is the focus. You know, the other thing about the gerrymander that we have in the state of Wisconsin is not only does it mean that the clear popular will of the majority of Wisconsinites has very little impact on what the legislature does, it also means that the political power of people who live in traditionally now uppercase D democratic areas, in Wisconsin that tends to be urban areas, have very little say over what the legislature does. And in our state, the way our state, the political and demographic geography of our state, that means that people of color, indigenous communities, have extremely limited opportunities to influence what the legislature does. And that means that environmental issues that affect urban communities or are associated with urban communities are often minimized or ignored by our legislature. And that's another harm that flows from all of this. And so I'm setting this stage again especially for folks who are not from Wisconsin, to just explain how and why in a kind of purple state like Wisconsin, this period from 2011 to 2017 could see the passage of legislation that is quite extreme and not actually reflective of the popular will of Wisconsinites. And the REINS Act is certainly an example of that. So to describe the REINS Act and what it is, I can actually bring this story to current day, and I think I actually literally mean today, because as you know, after a lot of negotiations between Speaker McCarthy and President Biden, I think today President Biden is signing the compromise bill that'll raise the debt ceiling. And for those who've been watching the news, you know that on the kind of further right end of the House of Representatives, members from that perspective did not like this compromise because it was not sufficiently severe in its spending cuts. And one of the key groups that first opposed and rallied folks to vote against the compromise bill was an organization called Freedom Works. And so I have on the screen an op-ed from the president of this organization, Freedom Works. And this is an op-ed from April, so earlier in the debt ceiling negotiations, where this individual was saying that, you know what, maybe we don't even need spending cuts. Maybe that shouldn't be our goal in the debt ceiling negotiations. Maybe we should throw in the REINS Act as our big win as part of these debt ceiling negotiations. And the author is suggesting that this would have been a bigger win for that far right perspective. So what is the REINS Act, right? It is a piece of federal legislation that was introduced for the first time in 2010, and it has been introduced in Congress in subsequent sessions, so every 2 years. And there have been different versions of it, but in general, what this legislation would do is require that any federal regulations that exceed a compliance cost threshold of a certain amount must be first approved by Congress. And so I want to tell you why that would be so problematic federally, but that will also foreshadow for you why it is currently so problematic here in Wisconsin, because Wisconsin has a state version of the REINS Act that has been on the books for the last 5+ years. So to explain this, I have to do a bit of Administrative Law 101, and that bit is simply that regulations, or sometimes called administrative rules or rulemaking, these are the ways that agencies carry out many bedrock environmental laws that have been passed by Congress. And it's important to note that agencies like the EPA, they can't just pass any regulations that they want, that the regulations are specifically authorized by Congress, and many times Congress has explicitly required the agency to promulgate these rules, and they're subject to a long process, which we're currently in, as Dr. Neary pointed out, with the Safe Drinking Water Act proposal related to PFAS. The second point here, though, is that administrative rules, that regulations, are part of the very structure of the environmental health laws that protect us. That when these laws were passed in the 1970s and the 1980s, like the Safe Drinking Water Act, like the Clean Water Act, that Congress specifically understood that environmental conditions change, that the way we as human beings pollute the environment will change over time, that technology for dealing with pollution will change over time. And so static laws in the statute book were not going to solve our environmental health problems, and that the laws would need to be continually updated to be effective over the years. It's part of the inherent design of how these laws work. And that's why the Clean Water Act, which was passed in 1972, over 50 years ago, can still be effective and protecting water in Wisconsin, even though it was something passed by Congress over half a century ago. So that brings me to why the Federal Rains Act is such a radical idea. And that's because by subjecting any regulation to an arbitrary compliance cost threshold and saying that unless Congress acts and approves that regulation, it can't go into effect, this is undermining the very structure of environmental health protections. It's a little bit like taking the engine out of a car and saying that you still have a car or that it's still useful. And what we've already talked about today in the room, as far as the example with the regulation related to the Safe Drinking Water Act, is a prime example of why the Rains Act would be so harmful. As Dr. Neary pointed out, back in March, the EPA proposed a Safe Drinking Water Act regulation for 6 PFAS compounds, and that is still going through the administrative rule-making process. And when finalized, as Dr. Neary said, that regulation will require municipalities, water utilities to install treatment technologies to bring PFAS levels down right at the level at which we can detect. And, you know, again, when the Safe Drinking Water Act was passed in 1974, the timeline that Dr. Neary had up for us shows that, of course, Congress could not have anticipated that PFAS would need to be regulated, but they intentionally charged the EPA to update those regulations when the science emerged to show that contaminants like PFAS needed to be regulated. So what would happen to that regulation, to that Safe Drinking Water Act standard, if the Federal Rains Act were in place? So I know from reading the newspaper and my conversations with Citizens for a Clean Wausau that Wausau recently installed some treatment technology with the water utility to remove PFAS from the water that, you know, we're drinking today, I think. And does anyone know how much that cost? And I don't need an exact figure, but just like a rough figure. Yep. A lot.
Current filtration is 800,000 roughly a year. The new filtration, which is coming, is 17 million.
17 million.
And
Per year to install. We haven't installed it yet.
Right, okay.
the current filtration, without the PFAS, when it was filtering without before that,
Yeah.
it typically lasts 17 to 20 years.
Okay.
$800,000. With filtering PFAS, it lasts about 9 months.
Okay.
So 800,000, yeah, every year.
Okay, so if this regulation were in place in Wausau, and kudos to Wausau for voluntarily doing this before it is required, absolutely. But if Wausau were doing this in response to a future Safe Drinking Water Act standard, would it cost the city, is it fair to say, maybe $20 million? Yep.
Yeah.
Okay, well, the thresholds that have been proposed for the Federal Rains Act are in the order of $100 million to $200 million across the entire country. So it would only take, let's say, 5 to 10 Wausau situations anywhere in the country before the Safe Drinking Water Act regulation that Dr. Neary told us was so important would be halted by the Federal Rains Act. And you know, in response, someone might say, well, it's not as if the Rains Act would absolutely prevent, that is, the regulation from going forward. It would just require Congress to approve it. And to that, I give kind of 3 points back, right? One is the practical point, is that it's just not practical for Congress to get involved at this level of detail. Again, the laws were designed so that Congress would not have to be involved in that level of detail. There are, in addition to this kind of high-profile Safe Drinking Water Act standard, there are thousands of regulations that are proposed every year because there are many complex laws to keep us safe. And $100 million or $200 million in an economy that is 25 trillion of economic activity is nothing. So many regulations would face this kind of scrutiny. So it's just not practical. But the more, I think, kind of principled point is that if a policy requires Congress to act and approve it, it's not a law, it's a bill, right? We gotta go back to Schoolhouse Rock. So the Safe Drinking Water Act, in some ways, would no longer be a law. It would be a bill where we would ask Congress again, can you protect our drinking water? It would be subject to that kind of political process and debate. And then the third point about the RAINS Act is that it is completely from the perspective of industry and polluters, because it only counts the compliance costs. It does not consider the cost to us from PFAS pollution, for example. It does not count the savings from and the benefits to our health of the regulations that are being proposed. And so that is why the federal RAINS Act is a terrible and radical idea. And thankfully, it looks like it's not going to become federal law anytime soon, which is good. But that brings me back to the bad news for us here in Wisconsin, and that is that Wisconsin is one of 2 states that has a state version of the RAINS Act. And in Wisconsin, our version says that if any rule proposed by a state agency exceeds compliance costs for all businesses, individuals, and local governments of over $10 million in any 2-year period, that the agency has to stop work on the rule, and that a bill authorizing the rule has to be passed by the legislature and signed by the governor. So we're back where we don't have a law anymore. And we'll talk a little bit about the effect that this has had on environmental health protection in Wisconsin, but again, I want to bring this back to the democracy issues before we go there. And that is that our state's bedrock environmental laws, our groundwater protection law, are laws that have been implemented to carry out the Safe Drinking Water Act and the Federal Clean Water Act, our wetlands protections laws. They were all passed in a previous era on a bipartisan basis, and they were extremely popular. The public was demanding these environmental health protections. But the RAINS Act has quietly, implicitly repealed the power and certain portions of these laws. So we have a problem of democratic accountability that popular laws have been weakened and implicitly repealed without our really knowing about it. And then we have a loss of democratic accountability because the way that these laws can be remediated, or the ways that we can get that power back, is by the legislature passing separate bills to authorize these environmental health protections. But we have a gerrymandered legislature that is not accountable and not willing to act in those situations as we have it right now. So, but let's talk about how we've seen the Wisconsin RAINS Act impact human health, environmental health protections in Wisconsin. And this law was passed in September of 2017, and actually since then, we have not seen it actually technically ever invoked or triggered, meaning no agency has proposed a rule that required it to stop working and then sought legislative authorization for that rule. But that's not because the RAINS Act has been insignificant. Actually, it's been casting a long shadow over what state agencies are willing to do and what they have been able to do. And we've already seen 2 extremely important rulemakings abandoned, in part and predominantly because of the RAINS Act. And the first one is a rule that was really a centerpiece of Governor Evers' clean water agenda when he was elected in 2018, and clean water was a major issue in that election. People in the room may know that nitrate contamination is one of our worst environmental and water quality concerns in the state of Wisconsin, that it is the predominant contaminant in our state's groundwater, that nearly 1/3 of Wisconsin families get their water from private drinking water wells, and estimates are that 100,000 or so Wisconsin families are getting water that is above the maximum contaminant level for nitrate. The big driver of nitrate pollution, about 90%, are agricultural inputs. And so as a result, a few years ago, as part of Governor Evers' Clean Water Agenda, the DNR had started work on some performance standards that would target the most sensitive and vulnerable regions for nitrate pollution, and they would slowly implement changes in farming practices to reduce over time the amount of nitrate that's in groundwater. However, in 2001, the agency simply had to, chose to abandon work on that rule when an economic impact analysis showed that the cost would be something like $20 to $30 million a year. And the agency did this because it knew that the RAINS Act would be triggered and that the legislature would never act on this rule. Around that same time, there was a study that was put out that demonstrated, I think rather conservatively, that just the direct medical bills attributable to nitrate contamination in the state of Wisconsin approach $80 million a year. And that, that's just the direct medical bills. It doesn't count lost productivity or other economic costs. It doesn't talk about the human terms of increased cancer, increased birth defects, blue baby syndrome. So that is a cost that we've had to bear in the state of Wisconsin as a result of the Wisconsin RAINS Act. Another is, and this has been alluded to, was when the DNR abandoned the setting of a PFAS groundwater quality standard. That is essentially the Safe Drinking Water Act standard for those folks who use private drinking water wells. And one of the main objections by industry groups was that the costs of that regulation were going to exceed this $10 million threshold, and that was one of the main reasons that the Natural Resources Board gave for ending that rulemaking prematurely. Again, this cost calculus did not consider what it is currently costing the communities around the state in French Island, Marinette, who are on bottled water, who cannot drink the water coming out of their tap. And these are just some examples of that kind of long shadow that the Wisconsin RAINS Act has cast over environmental health protection in our state. And surely there are other rulemakings that have never even started because of this roadblock. So that is a huge, huge challenge. But compounding that challenge, we've seen industry groups initiate litigation that attempts to force agencies like the DNR to then go through the rulemaking process just to use the regulatory authority that they currently have as a way to further roll back environmental protections. And I want to tell you about a couple situations like that. And in this case, actually, I can tell you about some victories and about some successes, including by folks in this room. So I'm excited to do that. One of these cases involves a situation that Midwest Environmental Advocates has worked on for a number of years. This case began all the way back in 2012 when MEA represented 5 neighbors of the facility you see on the screen there. That is Kinnard Farms in the town of Lincoln in Kewaunee County. The neighbors that we represented challenged a DNR permit that allowed that facility to expand. And those neighbors had already seen their water contaminated by bacterial and nitrate contamination. And that's in large part due to the sensitive geology in that region. There's an example of water that has come out of taps in Kewaunee County. Kewaunee County is the worst place to concentrate large quantities of manure that then seeps into groundwater because the bedrock under Kewaunee County, like much of northeast Wisconsin, is characterized by fractured karst geology and very shallow soil depths. So that means that nutrients, manure that exists on the surface very quickly seeps into groundwater where these contamination issues are prevalent. So over the years, our clients had seen their water become more and more contaminated. They saw DNR's response, the state's response, become more and more ineffectual. And so they took a stand and challenged this permit. This is on the screen there is Linda Koshart, who is one of the petitioners, and I just want to read what motivated her to take a stand. In her own words, she said, "I remember the time my granddaughter fell on the farm and cut her hands and knees. In the immediate response, she ran to the restroom to wash them off. I didn't want to frighten her, so I suggested that we rinse the cuts with a nice clean bottle of water. A 6-year-old should not have to worry about safe water to wash her cuts, hands, or face. I had a very unsettling night that night, worrying what I might have exposed my precious granddaughter to." And Linda's concerns were actually very well founded, because at that time she was fighting a MRSA infection, and her son nearly lost an eye to a MRSA infection. So therefore, MEA represented Linda and her neighbors to challenge this permit, and we asked the DNR to impose some conditions on the permit, including a limit on the number of animals that would be allowed, to be more reflective of what was safe in that location, and also to monitor the groundwater under the fields where the manure was being spread. And in 2014, an administrative law judge agreed with us, agreed with our clients, and found that the contamination that existed was the result of a massive regulatory failure. Rather, though, than accept that kind of common sense compromise and those common sense conditions in the permit, industry groups challenged this decision all the way up and down the Wisconsin court system for many years. And they argued, again, that DNR, to use its existing permit authority, needed to promulgate new rules. They argued that the DNR could only respond to this situation if it promulgated rules that verbatim allowed it to impose these kinds of conditions. Again, that's not how environmental laws are supposed to work. The agency is supposed to be able to address the facts and circumstances in that particular situation. And it took all the way until 2021 for this case to reach the Wisconsin Supreme Court and be decided there. But thanks to the tenacity of people like Linda, we were victorious, and the Wisconsin Supreme Court ruled that the state has the authority, has broad authority to impose permit conditions to respond to these kinds of situations, that it does not need to go through the rulemaking process to spell out these conditions verbatim. And that ruling has an effect on CAFO permitting, certainly in the state of Wisconsin, but it has a broader effect because, again, public health and environmental laws are designed so that permitting conditions can be flexible, and the agency has broad authority to respond to those kinds of conditions. So it applies in a variety of contexts. The second example I want to give of industry groups attempting to litigate to force the state into a rulemaking process that is in many ways destined to failure because of the RAINS Act involves people in this room, and it involves the issue that we were just talking about. In 2021, Wisconsin Manufacturers and Commerce, our state's, I think it's safe to say, most powerful, definitely biggest business lobbying group, sued the DNR over the DNR's use of the spills law to address PFAS contamination in places like Marinette and French Island and across the state. And WMC in this case put forward the claim that until DNR promulgates a rule that specifies every possible hazardous substance and the quantities and concentrations in which they could be hazardous, the DNR has no authority under our state spills law, which has been operating in our state for over 40 years, since 1978 when it was passed. This radical claim would not only take away the main regulatory hook that we have in the state of Wisconsin to respond at sites of PFAS contamination, it would apply at thousands of sites, because the list of contaminants that WMC thinks needs to be available before and promulgated through the rulemaking process before the state has any authority under the spills law doesn't exist because it's never been necessary. So it would apply to situations like those on the southwest side of Wausau. It would apply to contaminants like benzene and dioxin, things that we've already talked about today. So in response to this, MEA, along with Citizens for a Clean Wausau, along with Wisconsin Environmental Health Network, Dr. Neary's organization, and 3 other interested parties have been participating in this lawsuit in defense of the spills law. And our assertion has been that we're right on the law, that the legislature clearly never intended for DNR to have to go through the rulemaking process to use the authority that it's been using for the last 40 years, but that it's also important for the court and the public to understand the very real-world human health implications of the radical argument that WMC is putting forward. And that's why the participation of people like Tom and Terry and folks here from the southwest side of Wausau has been extremely important. This is a screenshot of a meeting that we had right before one of the court hearings in the lawsuit. And one of the kind of silver linings of litigating during a time of COVID is that you could litigate from anywhere because you could appear virtually. So in fact, any attorney, Rob Lee, in this case, appeared actually in this hotel with Citizens for a Clean Wausau at his side. So as Rob was telling the judge about the impact that WMC's lawsuit would have in Wausau, the neighbors and the community members who would be affected were right there with him. This litigation is making its way through the appellate process. It is destined, I think, to be decided by the Wisconsin Supreme Court. It's only gone through the trial court level. WMC was able to pick where it filed its case because it was the plaintiff, and it, to some extent, had a lot of say over which judge heard the case. So unfortunately, that judge agreed with most of WMC's legal arguments, but critically, that judge agreed with us that the spills law should remain in effect during the appellate process. And when you're a trial court judge deciding an important legal issue like this, you know that what you say about the law is going to be completely reviewed and redone by the appellate courts. What really counts is that the law remains effective and stays in place. And thanks in large part to folks like the members of Citizens for a Clean Wausau, the spills law continues to operate and protect folks in Marinette and French Island and countless communities across the state. So I want to kind of wrap up and just bring out a few kind of themes of what I've tried to talk about today. One, as I said at the beginning, in Wisconsin we've seen how this erosion of democratic accountability has had a dramatic and direct effect on public health protection, on environmental health protection in the state of Wisconsin. The kinds of rulemakings that we've seen abandoned in previous decades would have gone forward with relatively little controversy. Sure, there would have been some lobbying, sure, maybe there would have been some compromise, but they would have gotten done in the end in a different era. The REINS Act is something that we are confronting as a huge obstacle here on the state level. Thankfully, it is still just a wish list. A wish list idea for conservatives federally, but we need to be vigilant, and I would encourage folks in other states and federally to not underestimate proposals like the REINS Act that attempt to rein in the bureaucracy, but are really directed at throwing sand in the gears of environmental health protections. Industry groups and special interests know that there's never going to be political will for outright repealing or even explicitly modifying in ways that are friendly to them laws like the Clean Water Act, laws like our state's Groundwater Act. So they use these tactics to achieve their ends in subtle ways. We need to be vigilant about those tactics here in Wisconsin, but especially in other states. And then again, even though we've been through a period where democratic accountability has seemed scarce and there have been many obstacles erected, we've still been able to achieve victories. We've seen groups like Citizens for a Clean Wausau make an important difference. And also to note that I think democracy is making a comeback here in the state of Wisconsin. We saw record turnout, record engagement in the recent Wisconsin Supreme Court election, and the main issues in that election included democracy, gerrymandering. And so I think the kind of structure that has locked some of these obstacles in place over the last 10 plus years is going to be loosening, and we are going to see better days ahead in the coming years. So again, thanks everyone for having me, and I'd be happy to kind of answer any questions and have a discussion.